Judicial Branch in a flash. It's all about the robes. Actually, it's not. The cool black robes judges wear are the first things a lot of people think of when they hear the word judicial. But the first thing you really need to know is how the courts were created. The only court the United States Constitution actually creates is the Supreme Court, the highest court in the country. The Constitution also allows Congress to create other courts. When Congress created those courts, the federal court system was born. Two court systems. Here's the confusing part. There are two systems of courts in the United States. The federal court system deals with disputes about laws that apply to the entire United States. State court systems mostly deal with disputes about state laws. Each state has its own court system created by its own state constitution. Whether people take their case to a federal or state court depends on the laws involved in the case. The good news is that state court systems usually work just like the federal court system. Which court to use? Each court system deals with certain kinds of cases. Federal courts hear cases involving federal laws, the U.S. Constitution, or disputes between citizens of different states. State courts hear cases involving state laws or the state's constitution. They also deal with disagreements between citizens of the state. State courts normally resolve the kinds of issues you hear about in everyday life, such as family matters, accidents, crimes, and traffic violations. Criminal versus civil. Most trials you see on TV involve a person who has been accused of a crime, but criminal cases are not the only kind of cases that go to trial. Sometimes people have a disagreement that they can't resolve on their own. Often one side feels that the other side violated their rights in some way. This kind of case is called a civil case. The goal of a civil case is not to find out whether someone is innocent or guilty, but decide which side's version of the story is correct. So civil is relating to the rights of citizens, and criminal is relating to crime. You're on trial. The trial court is the first court to hear a case. Both the state and federal systems have trial courts. In the federal system, the trial court is called a district court. In the trial court, lawyers use evidence to try to prove that their client's side of the story is really what happened. Evidence can be almost anything. Witnesses, videos, photographs, a letter, a piece of fabric, or even a murder weapon. In a trial jury, a group of 12 people listen to the evidence and decides who wins the case. That decision is called a verdict. In a bench trial, there is no jury, so the judge gives the verdict. Think about Judge Judy. It's not over until it's over. Losing in the trial court doesn't mean the case is over. If the losing side thinks there has been an error, they can ask a higher court to review the verdict and replace it with a different decision. The courts above the trial court are called appellate courts. The federal system and most state systems have two appellate-level courts, a court of appeals and a Supreme Court. Your state might have a different name for those courts. In Pennsylvania, those are the names that we have. Asking an appellate court to review a case is often called making an appeal. Appellate courts can affirm the trial court's decision, letting it stand, reverse the decision, or remand the case back to trial court to start over. Going up, and sometimes down. Want to sound like a legal eagle? Then you can say the case was brought up on appeal. Cases that are thought of as going up through the court system. A trial court decision is brought to the appeals court. An appeals court decision is brought up to the highest court. Once a case has been heard by the highest court, there is nowhere left to go. Appellate courts review lower courts' decisions to see if a mistake was made. When an appellate court makes a decision, all lower courts must follow that decision in the future when the same issue comes up again. So just to review, the trial court hears cases for the first time and reviews evidence of who is right. Then goes up to the Court of Appeals, which reviews the trial court decision for error, and decisions must be followed by all trial courts. From there we move up to the Supreme Court, which reviews the appeal of the court decision for error, and decisions must be followed by all lower courts. Judges and more judges. While a trial court only has one judge, most Court of Appeals cases are heard by 3 judges. When more than one judge listens to a case, the group of judges is called a panel. Usually the judges decide the case by a majority vote. At the appellate level, there is never a jury. That's because a jury's job is to look at evidence and decide what happened. In an appellate court, the judges are deciding whether legal errors have been made. For the losing side in the Court of Appeals, there is one more chance, the Supreme Court, which is the highest court. And that's final. At the U.S. Supreme Court, a panel of 9 justices hears the cases. State Supreme Courts often have fewer justices. The Supreme Court gets to choose which cases to take, and doesn't take very many. Often, cases that make it to the Supreme Court are disputes about whether a law goes against the Constitution. Once the Supreme Court has said something is unconstitutional, that's it. Only the court itself can reverse that decision. The power of deciding what is constitutional is called judicial review. The U.S. Supreme Court has this power over federal laws. State Supreme Courts have it over state laws. Here's what you need to do to make sure you finish everything today. First thing, take the quiz. You know the deal. 3 questions, 6 points total. 1 point just for answering a question, 2 points for getting it right, 0 points for not getting it done on time. Open book, open note, and open internet. Find the answers where you need, but I recommend going back and listening to the video to find answers. Then we need to complete the review activities. They're checked for completion, and answers are provided on the following slides, along with guidance and instructions to find the correct answers. So make sure that you are following along with everything that happens on the next couple slides, and we get our work done on time. Okay, we have 3 quick review activities to do before we finish up today. Let's go over our first one. A, complete the sentence. Use the terms and ideas that you have learned in this lesson to finish each statement, and these go in the same order as the reading. Number 1, the only court the Constitution creates is, and that court is the Supreme Court. That was one of the first things that our reading said. The 2 court systems in the United States are the federal court system and the state court system. And those systems often look very similar, but they hear different laws. And then the last one that I'm going to go over with you are what are the 2 kinds of legal cases. And those are criminal and civil. And I want you to really think about those differences because that is one of your quiz questions, and I can guarantee you that question will be on your test. You have 6 other questions to work through, so go ahead and get started on those. They should be pretty straightforward, and just remember they do go in the same order as the reading. Next one, making connections. Decide whether each description fits trial courts only, appellate courts only, or both, and write the letter of the description in the correct part of the diagram. Do yourself a favor and please just write a letter. If you make any attempt to try to write out the whole thing, you're going to have nowhere near enough space. So the first one, A, here's civil cases. Well, that's going to go in both because it could be in the case comes up in a trial court, and trial courts can hear either criminal or civil cases, but you can file an appeal in criminal or civil cases. So that means an appellate court would hear it, so it's going to go in the middle. Might not have a jury. Well, or might have a jury. That's going to be a trial court because juries are there to listen for evidence, and that is their only job, is to listen to the evidence and try to make a decision. In an appellate court, the evidence doesn't matter. All the evidence has already been presented, so there's no need for a jury. And then let's do one more together. And that is, does not hear cases for the first time. Well, that's what an appellate court is. It is the next level of a court. So, move on to letter C. Number each set of events to put the 3 events in the correct order. So we have, let's do the first one together. Our 3 things are the Court of Appeals remands the case, a new trial begins, or the first verdict is appealed. So let's think about this one. So in order for something to go to the Court of Appeals, it means a decision has to be appealed. So we can't go to the Court of Appeals can't make a decision if there's no case. So the decision would have to be appealed first. Next, well, is either a new trial going to begin, or does the Court of Appeals has to do something? Well, the Court of Appeals has to do something. So they remand the case, which means they throw out the old one and start new. And then, of course, our last one has to be a new trial begins. So look at the last 3 and take a look at those. And then we have one last thing to talk about on the next slide. This is a big, nasty, ugly, really difficult crossword puzzle. As usual, crossword puzzles are optional for extra credit. I will not force you to do it, but if you want to get some extra studying on the Judicial Branch, I recommend doing this. If you do it, show it to me, and I will throw some extra points on your test. All right, well, you should have everything that you need today, so go ahead and get started. If you finish, it would be a good time to work on your study guides. You do have a test coming up, but otherwise, go ahead and get started. Ask if you need any help.